Okay, good afternoon, folks, and welcome. This is, as I hope everybody knows, a monthly meeting and training opportunity from the Quattrone Center, which is funded through a grant with the Bureau of Justice Administration. This month, we are welcoming Dr. Jennifer Weintraub, who has did her research at Albany on wrongful conviction organizations, innocence organizations, their intake procedures, and how that impacts the ability of them to work to exonerate individuals. And is there a connection between intake criteria and eventual wrongful convictions? And we invited Dr. Weintraub because this is an issue that we hear from folks a lot about: intake criteria, screening criteria. How do you move cases forward more quickly? What types of intake should we be doing? What kinds of questions should we be asking for that? And her research just touches on this so beautifully that we thought she'd be a great opportunity to kind of kick off this year's meetings with this question. And we do intend to kind of come back to this question from different researchers and different experts throughout the year, and give an opportunity to really think about how do you conduct your intake, how do you conduct your screening, and how does that impact your ability to move cases forward as you are going through. And that's, again, whether you're a prosecutor in a conviction integrity unit or a staff member of an innocence organization. It's a pretty universal issue that we all have to face. So Jennifer, I'm just so grateful to have you here with us. And it's lovely, as Kia's saying in the chat, when you're coming on, please go ahead and mute yourself. Don't be offended if I do it for you as you're joining in. As always, we encourage folks to have your cameras on because it's always nicer to talk to people with actual faces. But if you're not comfortable or able, of course, we understand that as well. So Jennifer, welcome. Thank you so much for making time for us from your schedule with the New York State Senate. I know you've got a lot more going on. I'm going to go ahead and stop my share and turn over to you.
Awesome. Well, hello, everybody. Thank you, Marissa, for the invitation. This is an area of interest of mine that I've had for quite some time. So I was really happy to be able to talk to some innocence organization folks for my dissertation about their intake, their policies, their procedures, some barriers they face, and that kind of thing. So as Marissa said, I graduated from the University at Albany with my PhD in criminal justice just this past spring. And I also currently, in my professional role, am a legislative director at the New York State Senate for the Deputy Majority Leader of the Senate. So I do want to make clear that I'm here today in my capacity only as a researcher and not as his legislative director. All right, so perfect. I will jump in, and you know what? I did have a couple of kind of just grounding slides, and then, if you can cast over me when we do questions, you're totally welcome, but let's see.
Sure. And as she's getting that up, just reminding everybody that we do encourage folks to have questions, to please put them in the chat. If you feel particularly brave and want to unmute and try to jump in, that's fine too. We just want to make sure that folks get questions answered, or if you have thoughts you want to share, please feel free to do so.
All right, there we go. Zoom told me there were errors, but it looks like they've resolved them. Can everyone see this? Great. It booted me. That's okay. I could do it without the screen. If I could pull up one diagram at some point, that might be kind of cool for everyone.
It was on before, but it just disappeared for a second.
Who knows? That's okay. So what I did just briefly is, as I said, I conducted interviews with folks who work at innocence organizations. I was able to speak with folks from 19 different organizations, 24 individuals over the course of 20 interviews. I mostly was able to speak with folks who were Innocence Network members, although I did have a couple that were non-Innocence Network members, not enough to kind of really compare across. But, I was happy to be able to get some of those folks in because I know that structures and policies can be very different across those two groups. So organizations varied in age. Most of them had been around for about 10 to 19 years, which I think kind of captures the bulk of organizations anyway. Had various regions from across the United States. I should say I did limit it to the United States. And then I did also limit it to innocence organizations, and that is not folks from conviction integrity units or other government based organizations, if they were defense organizations, for example, doing innocence work that were receiving state funding or were part of a state defender's office, just because I know that the structure can be very different. The funding is obviously a little bit different between the folks who are nonprofits or law school affiliated versus those who are affiliated with the state. So did those interviews, recorded them, transcribed them, did some fancy stats, and basically was looking for themes across a couple of things. I was looking, first of all, kind of more descriptively, what are folks' policies for intake? Those policies are generally listed on websites, but I actually I took inventory of what folks said on their websites and then wanted to talk to them about it to get a feel for, are these all policies that, you still abide by? Some of them had updated. And as I'll kind of get into a little bit, some of them were more or less strict or flexible with their criteria. So an organization may have, a sentencing criteria on their website, but sometimes when I talk to folks, they actually indicated to me that that actually, it's kind of a guideline, not so much a criteria. So that was something I was really interested in. I wanted to get a feel for folks' procedures. I know that, obviously every innocence organization is kind of built differently. I don't think one was like the other. And so for that reason, they all had actually really different processes, which is something hopefully I can pull up and show you. So that was another thing I was looking for. And then what I was also interested in was kind of looking at, okay, with these policies, with these procedures, how might that influence what we know now about wrongful convictions, specifically for wrongful convictions from innocence organizations too, say, for example, there's a certain type of crime that is regularly weeded out during the intake process, or vice versa, ones that they look for more often than others because maybe they're easier to litigate or easier to investigate, might, account for an over or underrepresentation of those cases in the National Registry and kind of in our data reporting. So what I ended up doing was I, first of all, asked folks what were your intake criteria, checked with them about their websites, like I said. And there were a couple of big themes. And I'm wondering maybe if right now, Marissa, might be a good time for the screening question.
Sure, no problem. So we are going to use an online tool to be able to, here we go, just share. And I think I fixed it now, Jennifer, that you probably, just to make sure that you can do it. So this is called Poll Everywhere for those who are familiar with it. So this is just kind of a test to make sure this is working right. So if you go to on your web, if you're on the line, you can go to pollev.com/MBB, and you'll be able to see this on your desktop. Otherwise, you could text MBB to the number 22333 to ask to join the room. So once you get in, just a quick test, see how we're all doing today. That's not particularly good. We're getting so many folks on the what is going on emoji, but okay. So you can text it by phone or you can respond online with that. Uh-oh, I was hoping we wouldn't see any angry faces, but seeing some. Okay, so it looks like folks are getting the hang of that. Before we get into anybody's feeling on the devilish side, I think we'll go ahead and go to the first poll. So the first thing we wanted to ask folks when you are doing screening, whether you're a prosecutor's office or an innocence organization, what is your main screening criteria and how you define that in your own words? So whether that's actual innocence, manifest injustice, potential wrongful conviction, however you define it, go ahead and type that in. If you're typing in multiple words like actual innocence, just use the underscore to connect those two and they all go in together. Okay, so requiring new evidence, actual innocence, manifest injustice, credible claim of wrongful conviction, innocence or wrongful conviction. Jennifer, are these helpful to you?
Yeah, absolutely. I guess I can kind of chime in as they're popping up too.
Sure.
So yeah, actual innocence being so prominently in the middle is something that is actually reflected in my research as well. So for all of the folks I spoke with, except for one, factual innocence was, one of their primary screening criteria for whether or not they would take cases. This is mostly because organizations expressed to me that they felt like A, they had the specialized expertise in this area, obviously, and B, that there were already defense attorneys kind of out there taking care of other work. And so they really felt like they had to stick with the biggest need, and the biggest need they saw were for those who were claiming factual innocence. Let's see what else is popping up. I saw new evidence was one of the first ones that popped up. There were a couple of folks, as you get further down the process, which I'll also talk about, that spoke about how new evidence became, I guess, increasingly important as they continued through their process of review. There was one organization actually where the person I talked to said that if the person writing in can't identify that there's new evidence out there kind of at the outset, either in their letter or in their very initial, application or screening application, they actually wouldn't take the case any further. There were a number of folks who were a little bit more flexible, but there was one that said, full stop, we kind of have to stop right there. And the manifest injustice cases is something I actually asked folks about too. My question was a little bit more broad. So what I asked folks was, in an ideal world with unlimited resources, do you imagine that your organization might expand from, since so many had said actual innocence was so important, from actual innocence to cases of manifest injustice, to cases of kind of procedural wrongful conviction? So if there was a Brady violation or some sort of constitutional violation, but the person maybe did commit what they were, charged or accused of or convicted of, would you expand? And again, the answer pretty much overwhelmingly from all folks was, there were a couple who did take manifest injustice cases, I will say, but overwhelmingly the answer was nope, we would take those unlimited resources and we'd put them towards innocence cases because our wait lists are so long, the need is so great. I can only imagine how many more folks we could help. So that was a really strong theme across, was that folks, and also, like I said before, there are folks out there who already kind of handle those kinds of cases. So we don't feel like we really need to muddy the waters and get in doing those. A couple of others, I see DNA popping up a couple times in a couple different ways. Everyone I spoke to, except for one organization, took DNA cases, and one organization was exclusively taking on DNA cases. I kind of was surprised by this because with the Innocence Project and Centurion kind of being the first couple, I know Centurion set a standard, and then Innocence Project came in, and were DNA exclusive. And so I didn't know if maybe once folks were coming in after them, if taking non-DNA cases might be, the word's not controversial, but it may be against the grain or against kind of the tradition, I guess, of the bigger organizations, although I know Centurion does expand their reach. But everyone basically indicated that not only was it not controversial or out of the norm, but that they were encouraged by folks, Barry Scheck and Peter Neufeld and folks at the Innocence Project to expand. And really, they expressed DNA cases were a little bit easier. They were both easier to, obviously, the evidence testing is a little bit more straightforward, if it is available, of course, and that litigation was a lot more straightforward if they could get those DNA results, which made a lot of sense. Yep, and then the folks who there were some who focused on specific non-DNA cases. There were folks who said, our organization really started looking into arson cases, and so those always kind of hold. We're always kind of looking out for those because just historically we're kind of used to handling them, and so that was another one. Let's see what else. A couple of others that that's probably all from the word cloud that I kind of heard from folks I spoke to. I will say that child sexual abuse was an interesting kind of policy of whether or not folks would take those cases or not, was an interesting thing, because most organizations that took these cases, they expressed that they took them, but also expressed that they were hesitant and a lot more cautious when they were reviewing those applications and those files. And that's because they were difficult to prove, both evidence-wise, and they were difficult to litigate. Some folks mentioned not wanting to alienate victims. Of course, there's always a need to be sensitive to that, especially folks who were child victims at the time or may still be young. And then they also cited just wanting to use, they took up so many resources, they wanted to use those resources on other cases where they felt they would really be able to make a difference and really be able to get something done. So that was interesting to discuss with folks because, again, like I said on the websites, it says we take these cases, and then I talked to folks, and that wasn't untrue. It was just that they expressed they're so difficult, and we have such limited resources anyway. We really have to think carefully about it when we're looking at those cases in particular. A couple of other big ones, obviously geographic restrictions were huge. Of course, that was mostly because of where attorneys and folks were barred, was the biggest reason for working either within a state or a multi-state area. Some of them chose those policies based on what other organizations existed around them. So, if there was another innocence organization nearby, they would kind of split duties. Or there was just a lack of resources to expand. Some folks actually started with larger catchment areas and then over time said, we really just can't faithfully kind of serve all these folks in our catchment area. We've got to kind of narrow it down so we can help everyone that we can reach. And again, with the waitlist issue being so prominent, that was definitely cited. Let's see. I would say that probably the last big one that I came across in my research was sentence length being a criteria. I will say that probably about half of organizations had sentence related policies, whether it be or crime type related policies. So whether it be, we don't take misdemeanor cases, we only take felony cases, or a lot more often it was we'll take cases only where someone has 5, 10, X number of years left to serve on their sentence. These were indicated by folks as the kind of the most flexible policy. It wasn't as if, if their policy was you can't have less than 5 years left on your sentence. If someone had 6 years, it's not like they, took their application and threw it in the garbage, right? So they were a lot more flexible with that. And another thing that was kind of mitigating, which, makes sense, is the collateral consequences that folks were facing. Maybe they didn't have many years left on their prison sentence, but if they were on a sex offender registry, then that was something that could influence an innocence organization to kind of bend that rule and say, we're actually going to take that case. There are collateral consequences of this person's conviction that would really impact the quality of their lives if we were able to resolve it. And I will say that's the biggest theme I saw in both this, kind of why folks selected certain policies, and also how folks evaluated cases throughout their intake process, is that need to and want to make an actual change in the individual's lives of those they're assisting. So, if there was a case that seemed hard to prove and it might be difficult and the evidence wasn't really there on first look, but, it was really heinous and there's a threat of something there. I mean, really, as long as folks thought they had a chance to change that person's life, they would generally try to devote the resources to do that. And that also came into play when they were selecting cases. So I'll switch it up a little bit to talk about intake procedures. Let's see if my my PowerPoint will cooperate with me, because I'd love to have this up, but we shall see. Let's see. Says it's loading.
Yep, there it is.
All right.
Wow, that looks complicated.
Yes, this was both the most and least, I think, favorite slide of my committee, I have to say. So what I'm just demonstrating here, which is kind of a mess, is that I figured I lost it again. Hopefully folks got to see it for a second. But what the graph really shows is that each innocence organization had their own really had their own process and really kind of flowed through that chart in their own way. I really don't think one organization followed the exact path of another from that initial letter that they got all the way to the decision whether or not to accept or reject a case, which some actually organizations didn't make that decision at all, I will say. So maybe that's actually a good place to do. I think you had a question about criteria for acceptance.
Sure.
Yeah.
1 second here.
Yeah, no problem. But yeah, that was really interesting to me too, because I kind of assumed that all organizations made a black and white decision, and it turned out that actually there were several that did not and would just kind of keep files and keep cases, on file and kind of return to them, never really technically close them or accept them unless they maybe found a break in the case.
Okay, so I've got two questions. One is for innocence organizations, what's your criteria for agreeing to represent a client? And the other is for CIUs, how do you define cases that you proceed on in court? So which do you want to start with, Jen?
We'll start with the first one, that's fine.
Okay. Okay, so this is for our innocence folks in the audience. You should be able to see it if you've already logged into the poll everywhere. If you're on your phone, you can just go ahead and enter that in. So it's really, if you're agreeing to represent a client, what's your kind of threshold level? Is it somebody that you believe or can prove to be actually innocent? Is it more of a more generalized wrongful conviction, whether or not they were convicted, they were involved in the crime? How do you define that criteria in your own words? Okay, and we're seeing some newly discovered evidence with their factual innocence, new evidence, all pretty consistent with, Jen, I think, with what you are finding.
Yeah, absolutely. Yeah. Newly discovered evidence as well. Like I said, that was another thing that did come up, and it came stronger into play, I think, at different stages of different folks' process. So, most would overlook it at the letter writing stage. They would say, we don't actually expect you to have new evidence of innocence at this point, or to be able to uncover it. So we'll kind of wait on that. But once folks had gathered legal documents, some requested laboratory reports, and that kind of supporting evidence, once they had all of that in and had reviewed that, and maybe like their 10 to 20 page application, new evidence of innocence was obviously high up in the bar of whether or not they'd accept a case or move it to investigation or whatever that looked like for them. So that makes a lot of sense.
And we can put the same question to prosecutors, to CIU folks. So this would be more if you were agreeing to relief or agreeing to proceed in court in some way to support relief for the applicant, and whether that be a vacatur or new sentencing or whatever. But what's your triggering decision-making process, I think, is what we're trying to get at. I'm not sure if I'm saying that right. Feel free to kind of throw in the chat if I just confuse the heck out of you. So we've got manifest injustice, new evidence, I think is the new, right? And remember to use that underscore if you're using multiple words, otherwise it comes up a little weird. Yeah,
it breaks it up, but yeah, it's really interesting to me about the manifest injustice. Like I said, I think I talked to one or two organizations that did say that, yes, we had relatively recently started taking those kinds of cases. And I've always kind of been curious to replicate this with folks who I excluded from this study, who were working at conviction integrity units and, state defense organizations. So that could be a really interesting difference between the two groups.
Yeah.
Yep. New evidence.
Meets the legal standard.
Yes, legal standard for new evidence also. That's obviously important. Unfortunately, new evidence alone isn't enough. It depends on the jurisdiction where you're practicing.
Right.
Yeah. Awesome.
Okay, great.
All right. Awesome. Thanks, everyone. So with that all being said, I'll kind of jump into just kind of briefly what the processes looked like in general. I will say that innocence organizations tended to follow the same kind of steps. So there was, an initial request step of assistance from the applicant themselves. Generally, most had an application stage. There was one organization I spoke with that didn't have a screener or an application. Then there's post-application review. Obviously, what's the next step after you've taken a look at the applications? And then, like I said, acceptance, or, putting people on a wait list, or, whatever that next step looked like. The range of requests received across organizations varied pretty highly. So I think it was a range of like 20 requests per year to 2,000 plus requests per year. So an average, again, on a really long range of about 500 a year. And I would say most folks indicated a couple of hundred applications a year. And I also was curious at that stage what staff thought, and I should say too, the types of people I spoke with at these organizations varied, but I generally spoke with either founders or executive directors of the organizations and Innocence intake staff, if there was specific intake staff. So with those folks, what do you think are barriers applicants face in reaching you guys? How, why might they not write into your organization, even if they have a factual innocence claim? I got a lot of answers about literacy and mental health. Makes a lot of sense. Language barriers, of course, depending on the area, especially. How to best express their case in a letter, because that can be incredibly difficult. And on the reviewing side, I had folks, be pretty frank with me that they try really hard not to look too much into if it was confusing to read a letter, not letting that cloud their judgment as to the actual merits of that person's case, because it can be difficult, to see this is hard to read, I don't really know if there's a case here. But that person may struggle with literacy or something else. And another big factor that came up was folks said loss of hope or trust in the criminal justice system, which I think is absolutely, fair and absolutely a consideration. These folks who have been wrongfully convicted or accused have really seen a darker side of the criminal legal system in most cases, and that loss of trust can translate to anyone who really interacts with it, even if you're writing to an innocence organization. So generally these requests were received by admin, volunteers, students, and kind of put together in a folder. And then triage was the next kind of big thing folks talked about. I would say about half of organizations said they didn't really have a triage system. And when I say that, I mean they had a first in, first out system, whatever order the applications came in, that's how they took them. Generally, those folks had exceptions for if there was like a procedural deadline in the case, if there was DNA evidence involved, actually, because that could be something that could be expedited. If the case was referred by another attorney, generally folks said they would kind of take those cases on a little bit more quickly. And otherwise, and post-conviction deadlines was kind of the biggest reason, if someone had to have their appeal filed within 2 years, and they're at the 18-month mark, they were going to try and get to that case as fast as possible. But there were actually a couple of organizations who had some really interesting triage systems. I think there were 2 who had kind of like a tiered prioritization system. And that was, like low, medium, high priority based on some of these factors, based on whether or not someone's still incarcerated. If someone has DNA evidence, that might knock them up into high priority because they'd be able to test that relatively easily compared to the other investigative resources they might have to use for other cases. Or different case types might maybe receive kind of higher prioritization depending on the circumstances. That was very individualized. And then there were 2 organizations that had a grading system, and both of those organizations use that grading system in different ways. One of them indicated that they both did kind of like an A through E standard grading. One organization said, we have our students help us. We grade the applications that we get and the letters that we get based on, the merits of the case, what evidence might be available, what pathways we might be able to take. And then, the most likely to be successful, or maybe the easier cases to take, those would receive a higher grade than those that maybe have a more difficult pathway or not much new evidence to go off of at this time. And they indicated to me, for example, a case that has a C letter grade might never make it to the next stage of review or investigation. But the other organization that indicated that they use a grading system was talking about how they use it more so to prioritize, but not so much based on the merits of the case, but based on what the organization had available resource-wise at the time. So and a case might receive a high grade if it's a shaken baby case and they just were able to resolve one of those, and the attorney who specializes in that area was able to take on another case or something. So that's kind of, it wasn't so much a letter of a C grade meant that case was never going to move forward. It meant that right now we really don't have the resources to deal with this. But in that vein, none of them were really rejected. They were just kind of assigned a grade, as circumstances changed, as resources shifted, they were revisited. So I thought those were two really interesting triage systems that I hadn't thought would exist when I started this. And then the next stage was, and I will say that this and the following, the application stage, were where most participants indicated that cases were closed or dropped or rejected if they were going to be for not meeting basic screening criteria, which makes a lot of sense. Marissa, I think you had a question about whether or not folks use applications or screeners.
Yep. Happy to put that up.
Cool.
Okay, so folks online or on your phones, you should, if you're online, you should see the question. If you're on your phones, you can just go ahead and enter in. If you're a CIU, either A or B. If you're an innocence organization, either C or D. And I will go ahead and share screen so that Jen can see what's going on.
Cool.
Okay.
Yeah, as these continue to come in and shift, especially since, like I said, I only spoke with innocence organization folks, I'm not surprised that, you know, we're seeing obviously a majority, if not solely yeses, because like I said, everyone I spoke to, save for one organization, used one of those. And it looks like the majority of CIUs do as well. So that makes a lot of sense. And I did talk with folks, I mean, especially when I was talking to executive directors and folks who ran their intake departments, talked about how they really struggled with and re-amended over and over those forms, trying to make sure they have appropriate language that folks who maybe have literacy issues can read, making sure their applications maybe not so long that it would actually, you know, it would actually dissuade someone from filling it out, or be too difficult that it would dissuade people from filling them out. So I know that's another thing that folks mentioned that they struggled with and continue to really examine and take feedback on.
Mm-hmm.
Awesome. Yeah. Yeah, so like I said, all the organizations I spoke with all use some sort of screening and or application form. I will say a lot of them used both. So they had a short screener that was maybe 2 to 4 pages, and then would evaluate that. And so long as it, you know, all the factual innocence, geographic location, no ongoing appeal, those kind of basic criteria were met, then they would get the full application. There were a couple of folks who mentioned that not everyone who, depending on what they wrote in their letter or what they wrote in their screener, not everyone would receive an application, because they had the staff had a concern about giving false hope to folks. They were afraid that maybe if they sent them an application, that person might get their hopes up that their case is going to be taken. But for the most part, folks kind of erred on the side of sending out those applications to collect more information. So who reviewed these also varied by organization. Sometimes it was 1 or 2 people. Sometimes it was intake staff attorneys, the intake director themselves, or law students. I did have one organization who did use students, law or undergrad, I can't quite remember, but who did use students, who said that they definitely could screen more cases out towards the outset if they did use attorneys versus students, but that's what the students were there to learn to do. So, you know, they were going to let them kind of have that first crack opportunity at taking a look at the applications. Several put together reports or memos based on the applications, just kind of highlighting what the claim might be, making sure obviously it's a claim of factual innocence for most of those organizations, what the legal pathways forward might be, what kind of arguments they might be able to raise in court, or what kind of investigation might be able to be taken next. And those were put together by various folks, again, intake analysts, students, staff attorneys, pro bono attorneys a lot of the time. And the other thing too is whether or not organizations would take legal documents at this point. So there were a handful of organizations that, you know, they would take both the application and at the same time ask them to send over any legal documentation they have, transcripts, you know, any of those supporting documents. And there were some who just kind of took a look at the application first and asked for those materials later. And like I was saying earlier, the folks who did collect all those legal documents, got transcripts, got lab reports, they were now, after receiving all that information, more likely to lean more heavily on, is there new evidence for us to uncover Is there a pathway forward? They were more likely to kind of use that as a guide to whether or not they would move a case forward than organizations who just had the application back at that point, because they understood they didn't have all the information. Folks also indicated that they were looking for known contributors to wrongful convictions when they're reviewing the applications, which makes a lot of sense. If you're seeing an eyewitness identification issue, if there's a potential Brady violation, et cetera, they were on the lookout for those things, maybe a false confession or indications that there might have been one, and that would kind of give them something to grasp at as well. I think there were maybe 2 or 3 organizations who did screening interviews, I think probably after receiving the application. And those were generally just to make sure to first of all kind of meet face to face with the individual who wrote in, and also just kind of it wasn't seen as a kind of a gotcha interview. It wasn't trying to trip them up, trying to see if their story is real, trying to see if they're lying. It was more so trying to make sure that the staff had a correct understanding of the case and the facts of the case. And some organizations, after all of this, after application review, moved on to investigation. And at that point, that's when, again, chance of success, legal pathways became really, really important. Even before that stage, there were folks who said, what are the chances, even if we do take on this case and expend these resources, that we would be successful? And that did have to weigh in. There was similar to triage. There was someone who spoke to me who said, people don't want to talk about this, but it's kind of heartbreaking to have to make these decisions. And it really is, it calls into kind of a moral, ethical question of like, I know that these folks need help and they all need our help, but we can only do what we can with the resources that we have. And so, unfortunately, sometimes we have to make the hard decision as to whether or not this is something that we can see through to the end. And if it's not, then maybe we have to hold off on it for a while until there's maybe a new development or new evidence in the case. There were a couple, like I said, so people wrote memos after receiving those applications. Some of them had really interesting, kind of unique processes. Some organizations would present to a panel of folks who worked at the organization, of innocent staff, legal staff, and then decide whether or not they were going to go forward. Some had, very few, but some had external law firms review and kind of take a look and say, what do you think of this? Do you think this is something worth pursuing? And then lastly, there was an organization that had a really interesting system where they had an external panel of folks who were prosecutors and defense attorneys and other criminal legal actors take a look and would kind of approve step by step, should we move forward with this part of the case? Should we continue, etc. And I think that's, and then at that point, like I said, some folks moved on to acceptance, which was generally like, we're going to retain us, we're going to take on your case. And that's when documentation would be signed to kind of create that relationship. Some never really got to that stage unless they went through investigation, really found something solid. So that varied across different organizations, of course. And so that's really what I found on the policies and procedures. I will say that when I was looking at kind of what does this all mean for what we think we know or what we do know about wrongful convictions so far, I think one of the biggest things I took away from it was the child sexual abuse cases and the kind of caution there, which, like I said, makes absolute sense. And I totally understand how you have to be, you have to be cautious with all these cases because you're expending resources one way or the other. But it was interesting because folks expressed that they did actually receive a lot of requests to investigate child sexual abuse cases. And they're not very well represented in the statistics for exonerations for folks, especially from innocence organizations. So that might be something that might just be an example of one type of crime or one type of incident where those cases are harder to try and take more time and take more dedicated resources. And so maybe there are potentially more of those that, aren't really seeing exoneration or seeing exoneration more slowly. And I think that's pretty, I'm happy to take questions and kind of discuss further, but those are the primary things that I found. And thank you all for hearing me today.
That's all terrific. Thank you so much, Jennifer.
Of course.
We'll kind of take a pause to see if folks had questions about Jen's research. In the meantime, I'm going to go ahead and set what we thought we would do is Kia and Jen and I will we'll set up 3 breakout rooms and just kind of assign everybody into it so we can kind of hopefully have some room for folks to have some discussion about these issues. We thought we'd start with the question of triage, whether your organization or your unit uses some kind of triage mechanism to go from an application to prioritize cases as they come through and how you're going to move forward in order to kind of save your resources. So we'll leave those, we'll assign those breakout rooms in just a minute and then ask folks at the end of that to come back to the main room here. So what that means is at the bottom right of your screen, you'll see a button that says leave breakout room. When you hit on that, you get the option of leave breakout room or leave meeting. Please just leave the breakout room. Don't leave the meeting, and that'll bring you back to the main room for us so we can kind of do a wrap up. So I'm going to go ahead and open those breakout rooms now. Everybody should be getting assigned to a room. So we ask you to please go ahead and accept that room and go through. So whoops, I should have hold it off on Jennifer and Kia and I, but I'll straighten that out in just a second. Where's Kia? Oh, did it work? Oh, okay. Awesome. Worked out. So for those who are still in the main room, if you're hearing this, go ahead and join the breakout room that you've been assigned to and go ahead and go join your discussion. Okay. I always love seeing all the little pieces pop up on my screen when folks are coming back. So just make sure we've got everybody back who's coming back. Looks like it. Okay. So I hope those discussions were helpful for you guys. One thing that we talked about in our group, and Kia, please chime in when you can, is if you have materials either on triage or intake, a questionnaire, a form that you use, a triage system that you use that you are comfortable sharing with other people, please email them to Kia or myself, and we will make sure that we get those out to folks. We'll compile them and get them back out. And then frankly, we'll keep them on file for ourselves. When people call and ask us for assistance, we'd then be able to provide those. Kia just put her email in the chat. Thank you, Kia. And I'm putting mine in as well. So whatever you're comfortable sharing, please feel free to share that with us. We'll give it a few days. We'll compile it and we'll get it out to everybody. So you have those materials, and we'll include some additional materials that we have developed at the Quattrone Center, a questionnaire that we developed with Shelley Thibodeau in Jacksonville, Florida for CIUs, and with Innocence organizations, as well as some other materials that we have pulled up. So that was we talked a lot about triage in our group. Kia, Jen, anything to kind of add from folks' perspective?
Yeah, we talked about triage, people sharing their systems, if they do a kind of grading system or number system, or if they do a first in, first out kind of deal. We had an interesting question as to how do you learn, or what kind of indicates to you when you're reading an initial letter, whether there's DNA or forensic evidence, or whether there's, how do you, what sends off those alarm bells for you? And so, we talked about looking at, if you get the trial transcript, looking at the evidence that was entered, looking at the witnesses that testified. If there's a forensic analyst testifying, then, that's an indication. And then just certainly if it's a sexual assault case, then, DNA, forensic evidence should, that's, a good bet. Trying to think what else. And people just generally sharing their grading and numbering systems.
Yeah, we talked a little bit. Yeah, we talked a little bit about triage as well, but talked a lot about screening and kind of what different criteria are available at different organizations, depending too on their missions. Some folks, have a broader scope than others, and some focus in more particular areas than others, which I think is really interesting. And yeah, the screening and the triaging is really undertaken by, it really is just dependent on what resources do you have available, do you work with students, and that kind of thing. So that was really interesting to hear from folks from different parts of the country on that.
Great. So at this point, I think I'm trying to kind of fix the polling here that we got here. If folks had kind of outstanding issues from your breakout rooms that you wanted to kind of talk about, that would be great. I'm going to go ahead and launch our post meeting evaluation here, just so that we have it before people kind of start going out. But I'm going to hand it back to Jennifer and for our kind of closing thoughts here as our guest. And thank you again, Jen, for giving us your time. We're very grateful.
No, thank you for inviting me. This is, like I said, this is something that I think is incredibly important. And I think it's incredibly, I think it's under discussed, particularly in academic research, of course, but I think it's something that, folks kind of take for granted. Yeah, we're going to have some sort of system and then we're going to get to the real work, but intake is really just truly, it's so important for not just prioritization, but this is the first step to whether or not cases are going to start making their way through a system that can find them relief, legal relief. So thank you all. If you have questions, Marissa, you have my contact information. You're absolutely welcome to share it. And yeah, I think it's just, something to keep in mind is just how important this whole process is. I know I spoke with folks who get incredibly burned out, not just from this, obviously this whole area of work, but kind of from the stress and the anxiety of having to make the decisions on kind of who's going to get assistance and who isn't. But really, it's imperative, of course, and there are a million different ways to do it, it seems, because that's, every organization just has their own system that works. And that's always evolving. So I think learning from each other is really one of the best things you can do.
Right. I couldn't agree more. And Jen, again, thank you so much for your time for us and for everyone else. As I said, we'll be revisiting this topic through the year. I'll remind that if you do have materials you're willing to share with us, please do. If you'd like to lead a discussion on this topic at a future event, let me know. We'd be happy to have you guys lead it more than us, certainly. And as always, looking for additional topics for our meetings. We've been asked to have somebody on an expert in forensics and ballistics in particular to talk about 3D imaging and how that's being used to solve cold cases or others. So we're working on that. We've worked on a few other forensic topics as well, but always please let us know what would be helpful for you. This is what we're here for, and we'd be very happy to put together whatever you guys would need. So thanks for filling out the post-meeting evaluation. I'm going to go ahead and stop the recording right now, but we will